but it's all down to hard work. So as you were saying, very long nights. If you are a junior in a big case that can last 3-4 weeks, I have memories of commercial court trials in London where you sleep 2 hours, 3 hours a night. You don't even understand how you get through it, but it's a team effort and everyone is doing it, and then the excitation of just being in court the next day, and you just keep going. But it's really hard work. But that's the only way. That's how you learn from your elders. That's how you develop a work ethos, and ultimately how you, when the actual challenges on your own come, hopefully you can then rise to them because you've got all these hours behind you, which mean, okay, I can handle it.
Right. Thank you, Salim. I completely agree that it's the hard work which lays down the basis for everything. And that also makes sure, when you get an opportunity, we make the most of it. I firmly believe that everyone has that one moment in their life or that one case which takes them to the next level. Has there been a case or an opportunity in your career which actually took you to the next level?
In fact, when it feels early to look back, but obviously you're encouraging me to look back, and I look back because we've got people who are even younger than we are. So let's look back and tell them where we are. But it does feel early to look back. But if I look back, then you feel, as you were saying, it's a journey, and there are big landmarks. There definitely are big landmarks. And maybe we rationalize it this way, but it does feel like you have big cases that forge what you become, or, for example, the sort of cross-examiner you become, or the sort of, how you make your arguments. And it's not just the case. I think it's also the people you work with on the case. And so, obviously, we had a discussion about what you might be asking me. And I must say I struggled with that particular area of questioning and in the end, I'm afraid I'm going to have to give you two answers, and because they're linked to two people who, to me, are very important, have been very important in my career. And the first is my dad, because in the early 2000s, I did a very, very long case, very small case actually. It was a $1 million case between a Malagasy entity and a US charity based in Madagascar, about rotten flour. That's all it was. But it ended up being an absolute saga, which I did with my dad. And I learned a lot from that case, more about, on strategy, on everything that was going on, including also on argument. So that's one case which I certainly think did bring me to another level. And then another case which I did, a huge oil and gas case, which I did with Gordon Pollock, who he wasn't very, as well known as, say, Johnny or others in our field, but because he had a wider spectrum of practice, he was a formidable commercial court advocate. And I worked with him on that case for 2, 3, 4 years, and it was absolutely amazing to see someone of that caliber in practice, to be able to work with him, to know that you could hone your argument with him before delivering it in the arbitration room. And so many lessons, but if I give you one, there was a challenge to the award, which we won the arbitration. There was then a challenge in the commercial court, and he was doing the main part of it, and I was doing part of it. And he stands up, and the judge tells him, "Oh, Mr. Pollock, you have 4 points, don't you?" He says, "No, I have 1 point." "Well, your argument has 4 points." "Yeah, well, the argument has 4 points. 3 of them are rubbish, as we all know. So I'm going to argue the 1 point on which I'm going to win." But think about this for a second. No one does this anymore. But that's what we're supposed to be doing as lawyers, right? We're here to discriminate between good arguments and bad arguments. But because of the culture which is coming from a certain country, and I won't say which because I think you all know which one it is, now everyone wants to hedge their bets. Everyone is worried about professional negligence, etc., etc. And in the end, I think we're doing everyone a disservice. We're doing the profession a disservice. We're doing the law a disservice. Because, and let's just come back to advocacy for a second. You stand up in front of someone, you tell him 4 of your points are, 3 of your points are rubbish, and 1 point I'm going to win on. He's going to listen to you. And at one point you're arguing, he's bloody well going to listen to you and think, if someone has the courage to say that, then, and that's the sort of person he was, and it was a great lesson.
Nice. That's really interesting to hear. So, Salim, I think we will now jump into the slightly technical aspects. And given that we have a young audience today and we have some practitioners amidst us, we wanted to touch upon some of the procedural aspects of arbitration. And we just want to pick your brain on aspects, like how you deal certain things. Let's start with the first step, case management hearings. I am sure you have had many interesting experiences. We definitely have had interesting experiences wherein the approach to a case management hearing is different from country to country and from lawyer to lawyer. I dare say in my early days, I've heard an international arbitration wherein on the case management hearing, people literally argued the jurisdictional objection on the phone. Has happened. So what you really want to hear from you is that, as a lawyer, what should we keep in mind? Like, how do you approach a case management hearing? What do you seek to achieve in it? And what are the difference when the case management is a commercial arbitration and if it's an investor-state arbitration for that matter?
Okay. I think, listen, the first thing is, it may not feel that way because we've now been living with them for some time, but it's actually a fairly recent development to have enshrined in arbitration rules the idea of a case management conference or a case management hearing. It's only, the latest evolutions of the rules that have made this compulsory. And so I think the first thing which we should congratulate ourselves about is that it exists, that, tribunals are now encouraged to grapple early on with a case in the same way as, this is something which was brought into the English White Book with the Wolf reform. So it's also fairly recent in English procedural law. So this is all the same idea, that the decision maker should not just take cases as run of the mill, but that a lot of resources can be gained, or waste of resources avoided, by making sure that you understand the case very early on and that you tailor the procedure for the case. And now, obviously, arbitration has all the tools for that. And what you want to avoid is procedural order number one. The procedural order which the arbitrator uses every time he has a case, which is just going to amend with the names of the parties and certain things, but otherwise it's the same. It's his little white book. Even though we're not supposed to follow procedural rules, it's that particular chairman's little procedural rules. So he's just going to use that for that case. So the idea is to avoid that. And that's now enshrined, but you were asking difference between commercial arbitration and investment arbitration. It's enshrined in commercial rules. For example, you don't have it in the UNCITRAL rules. And so a lot of cases in investment arbitration will still proceed without such a hearing. ICSID does have it, so there you would have it. And I think pitfalls to avoid, or the way to make it useful, is just to bear in mind exactly what I've just told you, which is this is something which is meant to ensure that resources are not wasted. It's the beginning of a cooperation on a journey of fact-finding and of decision-making by a tribunal. And it's really an opportunity where opposite lawyers have to learn to work together, while making sure that they create the space where they will be able to make the arguments that are going to oppose them. And if you keep all these factors in mind, then it should work. So, if you know that you have very strong jurisdiction objections, rather than argue them at that first meeting, you make sure that when preparing the agenda for the meeting, you already make it clear to the tribunal that you are going to ask for jurisdiction to be determined first, therefore there's going to be bifurcation. And you might be surprised, in some cases, your opponent is going to say, fine, we're happy to have jurisdiction determined first for whatever reason it suits them, but you must already, but it entails, for the advocates need to have thought ahead so that they then force the tribunal to think ahead as well. So, I know I've got jurisdiction points. I have thought through, is bifurcation to my advantage or not? If yes, why? What are the arguments? And all this then feeds into the agenda. It's obviously not going to be decided at the case management hearing, but it means, okay, tribunal knows that's the next phase and all this is factored in.
Thanks. Thank you.
And it just to pursue a little bit further, it's not, unfortunately, it's not because it's in rules that is going to have an effect. And I think one has to be a little bit realistic, not disparaging anyone, but arbitrators are very busy. Some of them are lazier than others. It's a fact of life, it's the same for everyone. So it's really, I think it really falls on the lawyers to make sure that the case management hearing is useful and will achieve the objective.
Absolutely.
Right. Thank you so much, Salim. That was very informative. Now, seeing this from the perspective of an arbitrator, how do you think that an arbitrator should approach a case management hearing?
Well, you should approach it exactly in that spirit. I.e., however busy you are, you started this interview with my dad, and again, we're talking to a younger audience, so I'll allow myself to say things I normally wouldn't. But when I was growing up, my dad would always say, there is no small case. There isn't. That's just case number 100. For that particular client, that's his case. That's his only case. That's a case which is important to him. And so what we should do, really, as arbitrators, is just, however busy you are, and if you're juggling a practice which also has counsel work, etc., just to remind yourself, okay, this might not be the biggest of all cases, but what should I try and do for this case to be heard in the best way possible? What tools should I be using for this to be efficient? Now, obviously, as I said, the lawyers have to help you. But I think if you go into the case management hearing thinking, I want this to be useful rather than this is just a procedural step, which I now have to comply with under the rules. Let's get this over with, and I'm just going to get my procedural number 1 ratified. That would not be the right spirit to go into the hearing with.
Right.
Well, thanks. We hear you. No laziness, and I'll make sure it's in the right spirit. And it's something we have seen. Very interesting. You mentioned the word fact finding earlier when you were referring to one of the purpose of doing this. And very interestingly, in India, when we ask for red fund schedule to be introduced in a domestic arbitration, there are pushbacks. However, it's a norm. It's a norm. It's an established practice when you look at international commercial arbitrations. In your view, where do you see document discovery? Do you see that the discovery of documents should be made more of a norm, or should there be party autonomy, or should there be decision of tribunal, and it may be treated as an situational demand? How do you see discovery really playing out in the Indian scenario as well as in international commercial arbitration?
Yeah, listen, I think on the international stage, that question has more or less been resolved, and I'll come back to that in a moment. But let's start where you started, which is the situation in India today. And it's, you were mentioning when we were discussing yesterday, that little webinar we had with Justice Malhotra and, about Indian arbitration. I think it's very important to understand that every single country, including those that are now established jurisdictions, have been through a journey which have brought them to where they are today in terms of acceptance or of where the balance between various things lie. And that journey, for example, in terms of disclosure, hasn't been a simple one, say, in France or in England, because you had to reconcile various traditions. And so to suddenly tell, Indian practitioners who haven't been, who may not know the story of how we reached that particular landing point internationally, that's what you must do. I understand that there would be pushback. You can't expect judges, etc., just to accept this at face value. They need to be convinced to understand also. This is why, capacity building is so important, and to explain the rationale for things is very important. Now, red fern schedules, I'm very happy for Alan that it carries his name, but what is it? It's just that's just a grid and how to put it, a form of putting together your disclosure request. But what is the landing point internationally? On one hand, you had civil lawyers who were not used to the idea of disclosure at all. Then you had, on the complete opposite extreme, obviously US-style discovery, where you give absolutely everything. Somewhere in the middle, I would say you have UK or English-style disclosure, but which was also fairly extensive. And so where we ended up was with this idea of very targeted, very specific requests, completely tied to the pleadings. And I think there the IBA rules have really helped in ensuring that even those lawyers who haven't grown up with the idea of discovery or disclosure have a very simple instrument which allows them to understand how to tailor their request, how this is supposed to work. And then I guess if you haven't grown up in that sort of environment, it takes a couple of cases to understand exactly how it works. But it's not rocket science. It's effectively, you're told you're not going to get everything. If you want things, make sure you explain to the arbitrator why it's particularly relevant to your case, why it matters, and then you can hope to get the documents. It's as simple as that. If you ask, so the approach of asking for categories of documents, for classes of documents, which you might follow in domestic proceedings, you can't have there. But so once you understand that there is this balance between a system which was to whom disclosure was completely unknown, there are other ways in France for fact-finding, which I can't say I'm perfectly conversant with, but they exist. And within the US, and we found this middle way. And it's useful because it allows proceedings to be, you're always seeking to balance two objectives, justice and efficiency. So if you explain all this, and it hasn't taken me very long, look, it's 3 minutes that we've been talking about this subject. So perhaps, the next time you have a recalcitrant judge saying, why should I adopt this red fern thing? This is simply a piece of paper, a grid, which is useful because then on one page you see the parties' various positions. But this is why we use it. This is why it's frequently used. And hopefully they will see that it's to their advantage to use it.
Absolutely.
Thank you. Thank you so much, Salim. You made a few right points that discovery could be used if it is used in the right way, it could be very beneficial. Now, continuing with that, my next question is that what are the guiding principles that one should keep in mind while seeking discovery of documents? And does anything change, in case of any e-discovery of documents?
Right, guiding principles. I think it's this idea of targeted requests. Which, it needs to be sufficiently specific. It doesn't mean that, you need to know there is one document and ask for that document. Obviously, it's not that simple. But it requires a proper analysis of the pleadings. It's actually useful also because, it's a first stage where you can make clear to the tribunal your view of the case, where the real issues lie. And you must articulate this sufficiently well in your request that the arbitrators will also see it quite well. That, right, I understand, this is a claim for expropriation. This is going to be relevant. You want the arbitrator to feel, I'm going to need this. I need to see those documents. That's ultimately, he's the decision maker. Or she is the decision maker, right? So I think if you keep in mind that guiding principle, you can't go very wrong. Now, e-discovery, I must say, I'm not a good thing with e-things. There are principles, whether you do it by sitting in a room with documents or you do it by sifting through hard drives. I'm not sure it changes anything at all. I'm sure it changes a lot for the people who do it in practice. But in terms of the principles you apply, I don't see why it should make any difference.
Right. Thank you.
I'm going to ask you something else then. I was about to ask you something in relation, but in your experience, Salim, have you seen what is the types of adverse inferences that you have seen being drawn up by tribunals when parties have not been honest in discovery or have not provided the documents? Like on the practical front, what kind of adverse inferences do you see other than maybe drawing of costs, imposition of costs?
In practice, the idea of adverse inferences, I think, is a stick, which means that the rule of discovery works well. I don't think it's used very, seldom will you actually see an award which is drawing the inferences. It does happen, but I think it's the exception rather than the norm. But the fear of it is what normally will lead parties to comply. And often I mean, thinking of recent cases where we've started really thinking now we're getting in a stage where the tribunal will have to draw inferences. Suddenly you see documents materialize, belatedly. But I can't think of the top of my head of a case I've handled recently where we've actually had to draw the inference on a formal level, saying the request was made, the documents were not produced, therefore we draw an adverse inference. It's more subtle than that.
Right, exactly. I think we share a similar experience.
Right, thank you. Thank you so much, Salim. Now, moving on to the next set of next stage of the arbitration, that is the witness statements. In your opinion, what are the main do's and don'ts, that a young lawyer or a practitioner should bear in mind while assisting the fact witnesses in their statements?
Right. You see, I came to arbitrations not immediately in my career. So I had a good 6 years where I was doing purely commercial court work. And that certainly influences the way in which I feel a junior lawyer should assist witnesses, which is to do with the fact that I was doing it under English rules, where there are fairly strict rules about not coaching the witness, the assistance really being quite limited. And now the reality in international arbitration is that everything goes. I mean, when we see these witness statements clearly drafted by lawyers, very long, mostly reciting the documents, I'm not sure. It's difficult because on one hand, I can see what I believe to be ethical. I can also see that they come from the fact that I've been brought up in a certain legal culture, which I believe has ethics firmly at its heart. So I do believe it's a good thing. So if I were to give you my personal do's and don'ts, that would be fairly easy. But then you have to live in the environment that we are in. So you cannot expect, you have to maintain a level playing field. If on one side you have a team of lawyers coaching the witness, and on the other side you've got, 3 barristers who say, no, I shan't do that. It's not going to work. So everyone is now accepting the reality of what goes on. On the other hand, trying to overhelp the witness, to my mind, always backfires. When you have over elaborate witness statements that the witness can't really relate to at all, that's not helpful, and the tribunal normally sees through that very quickly. When you've had someone who's been overly coached, that also becomes fairly obvious fairly soon to an experienced tribunal, I think.
I think you made a great point about coached witness, which brings me to my next obvious question. If we are cross-examining a coached witness, what do you expect us to do as lawyers?
Okay, sorry, again, a tip that comes from my dad. But it's this. I still smile when I think of it. One day he tells me, your job is not to convince the witness. It's as simple as, if the guy has been coached, there are many different types of witness. But, from time to time, you will actually have an honest witness. It does happen. And then, yes, you can have a dialogue, a perfectly reasonable dialogue with that witness. And you will get what you will feel are concessions that are what you needed for your case. Sometimes they can be fairly drastic. And these are all moments we live for. I mean, it's wonderful. And even better when it's not an honest witness and you still manage to get him to crack. But a witness that has been coached to death, who has been told, come what may, never say that, is never going to give you that concession. So at the end of the day, as my dad said, your job is not to persuade him. Your job is to persuade the tribunal. So all you can do with a witness like that is to make what he's supporting look and feel totally absurd. So that's the line to take, not to get frustrated because you're not getting that one answer. There will come a point where it becomes obvious he has been told, do not give that answer. Fine. Keep asking questions around that, which makes his refusal to give that answer look risible. And then you've done your job.
Absolutely. Also, I think may not be an exact follow-up, but the concept of cross-examination in arbitrations is quite different from what we do in commercial litigations. And I think even the cross-examinations in arbitration have come a long way. You don't see 150, 400 questions anymore. It's time-bound. And the most important fact is that tribunals are very well read. I mean, we have heard stories about you, but I think we also know of tribunals where the arbitrators will straight up pick, hey, why do you go to page 456 of Common Core, this letter, and tell us about it? And that's something which has been increasingly evident in international practices. In light of that, what do you think would be a tip to the young lawyers about their advocacy skills and approach to a tribunal and cross-examination on a more holistic basis rather than picking and choosing a particular style to suit a tribunal?
Right. First of all, as you're saying, in arbitration, one has to live with the fact that you're going to have limited time. So you can't have indiscriminate questions. You need to be fairly clear about what you're trying to achieve and do it crisply and fairly quickly compared to, say, again, going back to England to a commercial court trial where you might have 3-4 days with a witness. That's not going to happen. If you have 2 days, then that's already a lot with a major witness. So that's the first factor. Then you say tribunals are very prepared. Some are not. And on a particular tribunal, you may have one person who's very well prepared and the others perhaps a bit less. So you need to be able to read your tribunal. And the problem is that normally the person who is very well prepared is in fact the most receptive to cross-examination because he knows what you're doing. He knows why what you're doing is going to help him in his fact-finding. Whereas if you haven't really read, then you easily get bored by things of which you don't see the relevance. So you need to be able to read your tribunal. I think there's been a tendency for practitioners to feel that because you've got limited time, because you have tribunals who are not always super well prepared, then it's easier to cross-examine in arbitration than it is, say, in the commercial court. I think, for me certainly, and I think that the tip I would give to every young practitioner who wants to go that extra mile, you should think of that it's actually the opposite. You need to carry out all the preparation that you would carry out in order to cross-examine in a forum where you would have more time. And then you need to be able to pare this down to the very essential. And that's super time consuming. But there's no, I think it's the one area of preparation that really is impossible to cut down on. You need to have the time, to completely embrace the documents, to know what you need to ask, and then make that extra effort of paring it down for whatever time you have. And once you've done that, the reason I'm saying this to you is that once you've done that, you will develop a lot of mental agility in your cross-examination. And so if it looks like either the witness is not responding as you expected him perhaps to respond, or the tribunal itself is not as receptive to a particular line, you've got the flexibility to move quite quickly and to other things because you've got a lot of material already with you, which you can have as backup, etc. So it's very tough. I'm not, everyone pretends that it just happens. One day you become a cross-examiner. It's not like that. It's tough work. It's tough. There will be moments when you fall on your face. People don't say that, but it's the truth. And the only way to guarantee against that as much as possible is preparation. And then as you do it, you become more agile at doing it.
Thank you so much, Salim. I think that's a very valid point because preparation is something which you can't escape. Now, coming to this present situation, we are in a very unexpected situation at the moment with the pandemic all around us. This COVID-19 pandemic has placed an increasing reliance on the technology, and that's one of the reasons you see a lot of webinar and teleconferences and video conferences these days. And it is also impacting the dispute resolution mechanism and also the arbitration proceedings. So how do you see, the art of cross-examination or advocacy being impacted by these virtual hearings and the current situation?
Right. It will definitely have an impact. Now, I haven't yet done a full virtual hearing as counsel. I've cross-examined by video link, and I've sat 2 weeks ago as arbitrator in a full 3-day hearing, in a fully virtual hearing. And what you see is the link. So just going on that one hearing, say, where everyone was virtual. It's a different atmosphere. You can focus very well. I think for the advocate, it must be a bit different having the arbitrator in your face. We're there as you see me now. You see your arbitrators. So it creates probably a different feel to the hearing. But very quickly, I think it disappears and you just get into the actual hearing and you can just get on with your arguments or cross-examination. And at the end of the day, advocacy, be it cross-examination or be it argument, is about persuasion. So I've never believed, in big rhetorical effects or doing things for the sake of impressing the gallery. It's about persuasion. I mean, what we're doing now is we are also engaged in an exercise of persuasion. I want you to believe that what I say is valid. It so happens that in our particular environment, you also want to believe that what I'm saying is valid because you organize this webinar. But you know what I mean? It is about persuasion. It is about human interaction, which is why, and that drives me to say, what I've seen at the moment is that people feel that for simpler matters, okay, let's go for that hearing. Let's not postpone the case. For more complex matters, for example, I had a big investment arbitration hearing as counsel in October. We've postponed that to May. And I think most counsel at the moment, I think probably arbitrators as well, feel if it's a really complex case, I want to be in the same room as the advocate. I want to see the witness. Maybe we are wrong. Maybe we are all wrong. And actually, the more we do this, the more we'll realize it works perfectly well virtually. But I think there is an apprehension at the moment that if it's truly complex, if really it may turn on very detailed analysis of novel points of law, on very difficult points of fact, which are technical, I'd rather be in the same room. That's the feeling at the moment.
Right.
From my point of view.
It's very interesting to say that because I think a lot of cross-examination requests, which we see where the tribunal is willing to entertain a cross-examination online. I think even as practitioners, some of us feel that, the body language, the nature of the witness, how is he really responding to it is very vital as compared to even if you have protocols in place to make sure that, he's not being tutored or any other things happening. So I think we quite agree with the sentiment there. Can I take up a question which has just popped up from an audience, Salim, before I go to my ninth? Mm-hmm. Avinash Barik, who I think is AIAC's registrar, has asked that due to the COVID-19 situation, we are seeing a loss of pre- and post-tribunal award procedures not being honored, in the sense settlements, escalation stages, etc. Is there anything that as councils or as institutions one can do for better risk management?
Sorry, so you're saying people are not honoring their obligations. So, for example, an award is delivered and people are not...
It's a tricky one.
Yeah, I'm not sure. I think the problem is that firms are facing cash flow problems, obviously. There's so much uncertainty about the future. You can also see that at the pre-stage where people are delaying, pushing the trigger on requests for arbitration, etc., etc. And insofar as one sees an increase at the moment, insofar as people want to stay in business and they have a reputation to defend, it's not something they're going to be able to do for very long at all. So, whereas there might be some leeway, first of all, you do it for a while, and what are you going to do? You know full well the person is going to sue you straight away on the settlement or on the award, and so you can get away with it for a few months. But I would hope that as this crisis eases, one will see people fall back on their normal level of not being honorable, shall we put it that way. You're not going to eradicate that. I'm afraid it's part of business. I would love not to have to say that, but it's the truth. That's what I've seemed to have noticed over my career so far. Not everyone is.
Thank you. Thank you so much. Now, coming back to a little, informal question and answer session. We would like to know that, we all have our share of funny or embarrassing stories from legal practice. Is there any story or incident that you would like to share with us where you have faced a similar situation and, how you navigated through that moment?
There is, there are many, and some I can't share here, obviously. But this hearing, which I was telling you earlier with my dad in Mauritius, between this Malagasy entity and this US charity, on so many levels was hilarious. We had this chairman from another, whatever we had, who had who was guided in his approach to arbitration by what would take place in his country. So, and you'll understand that when I tell you we had 55 days of hearing on a $1 million case. And what was really funny, and often is the case in life, isn't it, is when you had two cultures clashing. There was such a disparity between the US lawyers who would come into the room with certain expectations and us. And this chairman also with completely different expectations. And we had Judge Lala, who was a Mauritian former Supreme Court judge with a huge sense of humor. And all this would boil over frequently. It was hilarious. Absolutely, absolutely hilarious. But more seriously, it created all sorts of problems. Because you were talking about discovery earlier, and we couldn't get this tribunal or this chairman to understand that time had come to get this US charity to give documents. And it was all about whether this particular flower was very simple. Had this flower rotted during the voyage, in which case they were liable, or did it rot when it got into my client's warehouse in Madagascar? And believe it or not, they would not order production of the voyage documents. And they, and they would say, well, we're a charity, we don't have the voyage documents. Say, well, how does that really? But anyway, so we laughed a lot, but by the end we were crying. And so what we did is we really went for the kill. So you say, how did I deal with it? And I said, okay, we're going to take the fight to them. So I instructed lawyers in West Virginia to go and do a USC 1782 application against the shipping line. And before they had time to breathe, before they realized what had happened, we did this over the Christmas period. We got all the documents from a very kind judge in West Virginia. And as soon as everything reopened in early January, we dumped all of this on the tribunal, and the case was over. That was quite a funny one.
That's one way to do it. To take note of it. Salim, couple of questions. Actually, a couple of questions that I want to ask you more on a personal front before we get into the technical queries that we are getting from our audience on the chat box. We know that you are a lawyer, an arbitrator, you love writing, and you teach. So how do you balance all of this, and which hat is your favorite out of the lot?
No, balance is very simple. If you don't sleep, then it's very easy to balance. No, I'm joking. But no, it all complements each other, doesn't it? I mean, initially I was lucky to get arbitral appointments very young. And initially when first of all, you're honored and you say yes. But the reason I kept accepting is because when you're on the other side of the table, I think it helps to become a better counsel. Because you see what works and what doesn't. Very simple thing, which is very obvious when you say it, but certainly for me as a young lawyer wasn't obvious until I experienced it on the other side, which is you make an urgent application as counsel. You send a 15-page letter. Of course you send a 15-page letter. You want to show the tribunal, you've grappled with everything, here's the law, here are the facts. And the arbitrators don't have notice of this arbitration, which is probably very urgent. They receive it at 8 p.m. or whatever, and they're pissed off. Sorry for my French, but they're not happy. And so short letters, short letters and to the point. And that's just one example. There's so many others. So that's how counsel and arbitrator work together. Teaching is a joy. I greatly enjoy that. And it also helps to be on top of the law, to remain on top of the law, so it feeds into the others as well, and writing as well. So it all works together. It all fits together quite nicely.
That's good to know. Also, we know that your favorite football club is Arsenal. However, if you have to pick between Manchester City or Manchester United, which one would that be?
Oh. There's the off chance that there would be family members listening in on this. I cannot tell you that. After the call, if you want, we may discuss that. No. These are, every question about the law, I'm very happy to answer. This is life or death situations. You can't put me in that situation.
Not gonna say it out. We know that. Okay. What I'll do then very quickly is I'll just take up some of the queries that we have popped up in the box. And one of the very interesting question, recurring question we see from a lot of young lawyers is, what is the central challenge faced by a lawyer when he begins his career in international arbitration? And I'll just take it a step further, that when you do your first role as an arbitrator, what do you think would be a central challenge in those situations?
Okay, so these are two very different questions. Let's take them in turn. So first, is the question from the audience member effectively, how do you break into this field? Is that the idea?
Yeah, as in either break in, and I think then they also want to know how to find their feet. Like what is it that you have to do?
Right. The reality is this has become ever more competitive a field. When I started, it was still fairly niche. I happened to be in the right set of chambers to do that. Now I'm submerged by, young lawyers from everywhere, from France, the UK, my home country, Indian colleagues coming up saying, how do I break into this field? And the reality is it's fairly tough. I mean, it's become very competitive. So there's no point not saying that. It's a fact, right? So you need to be willing to put in the hours. You need to be willing to accept that it may take some time. I think law firms, you might be better placed, the two of you, to know how you're recruiting, but it seems to me that going the extra mile of having very good masters, LLMs from Oxford, Cambridge, Harvard, if you can get them, the top universities, even if your first degree isn't there, but then showing that you want to push further and have that extra degree, it's very helpful. So, for example, the masters that I used to teach at King's, that sort of thing. So that's helpful. Once you are given the opportunity as counsel on a big stage, then just don't let yourself down. Prepare very hard. There's no point in being daunted about anything. I think, arbitrators are very receptive to young lawyers. Everyone is aware that there's a lot of talk about, obviously, legitimacy, about allowing practitioners from every country, every jurisdiction now to flourish, to also make sure that the next generation of arbitrators don't all come from the same countries again, that there's more representativity. So I would say 99% of arbitrators are very aware of that. So you will be given a fair chance as an advocate. So you begin with goodwill. And then it's all down to you not to let yourself down and to show the tribunal that goodwill is not misplaced, that you're not wasting their time, that you're going to the arguments that matter, that you can explain to them in crisp words why they matter. No one expects you to perform like Gordon Pollock on your first performance. It doesn't work that way, and everyone knows that. But they expect you to understand what your role is and to deliver well. And if you keep that in mind, it will be fine. Now, your other question is, as arbitrator, what do you do? Again, be well prepared. That will mean that you stand out. Don't show off, because you do see that a young arbitrator will want to show that he's ready or will intervene at the wrong time. Well, you don't need to show off. It's so long as you keep in mind this is a process of rendering justice. It's a process whereby I, arbitrator, need to understand the case. these opportunities will come for you to also find your feet as to, with the rest of the people in the room, with counsel, with your co-arbitrators, where you will earn everyone's respect and you will yourself feel better about what you're doing. It's fairly straightforward once you find that early moment.
Thank you. Thank you so much, Salim. Another question, and I think this could be the last one which has popped up, and which takes us back to the technical aspects, which is cross-examination. So, what tips that what are the tips that you would like to give to in respect of a cross-examination of an expert witness? Is there something which is different from cross-examination of a factual witness?
Yes, it is. It's definitely different. It's definitely different because you are, by definition, when you're cross-examining a factual witness, we're all operating on the same level, which is what is expected from reasonable people in normal life. That will be the sort of standard by which the performance is going to be judged, right? That's what tribunals are going to expect. When you raise an eyebrow at what a witness says, what standard, why are you doing that? Because suddenly an answer has come, which if you compare it to the way in which a normal person would react, doesn't seem to be normal. So that we all have this sort of in common, although it can be tricky because sometimes, we don't have all the same assumptions, but that you manage that. That's factual witnesses. Expert witnesses, you start from a very different hypothesis, which is you are on the battleground of this particular person. He's an expert. I did a case a while ago for a big pharmaceutical company, and it was all about antibiotics, and it turned around the risks that went with that antibiotic, which were cardiac risks, and the benefits that go with it, which were you treat infectious diseases. So these were two areas of expert evidence. And there was a third area, which was what regulators do, which is to balance that risk with that benefit. Now, if you're going to be cross-examining one of the top cardiologists in the world, you're not starting on the same plane as him. You need to get to the same level of expertise as he is. So it does mean immersing yourself in a particular subject very, very deeply indeed. And one should not be afraid of doing that. And if you're going to be able to cross-examine well, you need to do that fully. So that for these 3 hours, these 2 days, whatever, you are discussing that particular point of cardiology at the same level as that guy is. And that, again, it's becoming a bit of a refrain, but preparation. But it's to my mind, it's one of the most amazing parts of our work. And something to look forward to. You discover so many things, and you're able to do it at a level which is wonderful. And often you realize that when you think you've understood something, and then so that's also, for example, you're making submissions on those expert issues, or you would introduce how you will come to them later. It's even more obvious then. When you try to explain to a layman in simple terms what you think you've understood in an expert field, you realize you haven't really understood it. Do you see what I mean? You feel you've understood it in your mind. You want to put it in plain terms, and you realize, okay, I have to go back to the drawing board. I need to understand this better so that I'm able to say it in very, very simple words. Whenever you see people using jargon, normally I think it means they haven't mastered their field.
Right. Thank you so much, Lee. I think with this question, we have exactly clicked the clock. It's 4 o'clock. Manvinder, unless until you have any surprise questions for Salim.
I think I will leave the surprises aside as Salim. But, there's just one quick question because there's again some chats which have come on this very generic last minute comment from you. One thing that there's a lot of perception, I would say, in Indian lawyers that enforcement of awards in India is a challenge. I think we have seen that the challenge exists in a lot of parts of the world, and it's not definitely centric to India. Can you just leave us with a comment with regards to how do you see different jurisdictions, and what really is your feeling as a counsel for so many days with regards to enforcement of awards?
It remains one of the big challenges everywhere, right? Unfortunately, now you really see that arbitration has two phases in most big cases. Not all, well, actually, a lot of normal commercial companies that trade will not go on to fight enforcement, and their reputation is too important, or they're within a trade, which means that you just honor your awards. That does happen, but I'm afraid in the sort of work I do with very big stakes, and compliance with the award doesn't seem to be the norm. So you almost feel there are two stages: one which is securing the award, and then the other which is enforcing it. And the answer to that is, I think, all these New York Convention roadshows, which ICA has so well put together, more and more awareness within the judiciary as to how to handle those situations. In Mauritius, so everyone does his bit in his own jurisdiction, and in India, we all, with you, with others, we're all working on it. And when you see what Justice Malhotra has been doing, I can give you the concrete example of Mauritius, which is that we have a designated set of international arbitration judges. So we have 6 judges of the Supreme Court who hear all these challenges to awards and all these enforcement applications. And we've made sure that they go to various jurisdictions. So they've all gone, for example, to the Paris Arbitration Academy to get training, which means they understand the field and they live it as well. They don't feel it's something which is foreign, which is coming to them. They feel they get ownership of this as well and understand how it works. And then hopefully you get the right decisions and you get them made in a timely manner as well. But it's by its very nature, it's very complex, and it raises all sorts of complex issues about the interrelationship between challenges at the seat, various enforcements in various jurisdictions, the acceptability of issue estoppel. It's a complex area, I'm afraid. I don't think you were right to say, and I know you're picking up on what I said the other day on the other webinar, but we should be careful about not overreacting about what's going on in India. We should definitely take steps to correct, but we should not overreact.
No, definitely, and I think the last amendment has gone a long way in making sure that it's become a much more steadier jurisdiction, and there's no uncertainties that it used to exist a few years back, and that's a game changer. But thank you so much, Salim, for doing this for us. We know that you got out of an ICC arbitration hearing, and we know we can't hold you back, but I'm sure that the audience will appreciate this. It's there on Facebook and YouTube, so anyone who wants to see this later will definitely be gaining from this. And we note the most important things that you said: work hard, practice, and quality over quantity. I think that's the most important takeaways for I think us as well as the audience in this session. And once again, for someone who's set up the law in Mauritius, made sure that it's governed by the PCA, which is something unique to, I think, only Mauritius at this point of time, and done so much for him to be able to relate to all of us, the young audience and the students. We really want to thank you for taking time out for this.
No, it's a great pleasure, Manavendra. It really is. Thank you so much for inviting me.
Thank you. Thank you so much, Salim. Thank you so much, Manavendra.
Bye.
Bye.